And as you know, Justice Apple is appearing remotely, so we're going to begin with a sound check. Mr. Wonio, could you test your mic, make sure it's on?
Yes, testing, 1, 2, 3.
Justice Apple, were you able to hear that?
No, I think you need to turn the mic on, please.
Testing, 1, 2, 3.
There you go. Thank you so much.
Perfect. Mr. Wittmack, could you follow suit?
Testing the microphone, Justice Apple.
Thank you very much. Working fine. Thank you.
And we can hear you, Justice Apple. Mr. Wonio, when you're ready, you may proceed.
Thank you. May it please the court. Counsel, I do want to introduce the court to our clients that have traveled here to be with us today. We have the Blacker family, the Reese family, and David. I'm sure his wife, Marcia, will be back in. I also do want to do one little shout out. It's my son's 5th birthday today, so he came to watch Dad in a rare chance to present in front of the Supreme Court. So happy birthday, buddy. With that, we'll get right into it. We're here to talk about a will contest, but more importantly, we're here to talk about the preservation of avenues to justice for wronged litigants in that context. More specifically, in the district court proceeding, our clients brought a series of claims, including tortious interference with inheritance. Summary judgment was brought, and it was argued that our clients needed to prove a knowledge element. In other words, David and Donna needed to prove that the defendants knew they were the expected beneficiaries. By merely showing up for their deposition and saying, we didn't know that, the court closed off that avenue for recovery. The entirety of my career as a lawyer, which is getting up there now, slowly but surely, this court has been a beacon, a bastion for injured Iowans, preserving avenues for recovery, not closing them off. And this is an example.
All right, but how do you, I mean, logically, how do you interfere with something you don't know about?
Fair question. The way we look at it is, Justice Mansfield, object subject. You're interfering with the succession plan, the estate plan. It doesn't matter who that's going to, and let me give you an example to show, and I'm certain you've looked at it, you know this is because of the intentional interference with contract and the relationship there. But let's assume you have 2 sons, Alex and Tad, we'll call them, to pick on my brother. Tyler interferes with your succession planning and ultimately secures through undue influence or fraud or duress everything for himself. If he shows up and says, I thought Alex, my knowledge was Alex was the intended beneficiary, and it turns out it was Tad, how is his conduct any less culpable? It's really parties and knowledge is a component of standing, all the same that it is an intentional interference with business contract. All you have to show or prove is that there was a contract. You don't have to prove the specifics, the parties, the terms. That's a component of standing. The same in a case like this. Knowledge matters not. Everyone has an estate or succession plan, whether they've drafted a will or not. So it's the object is the succession plan.
What if it's intestacy? Then there isn't a succession plan, right? There's just sort of inertia, right?
Well, the state's provided you a succession plan. It's going to somebody.
But for interference with contract, you have to know there's a contract out there that you're interfering with. It's not enough just to pursue some end by aggressive or even wrongful means. You have to know there's a contract, right? Why shouldn't it be the same for interference with an inheritance?
there's a succession plan for every single person. Why would we prove the need to prove a succession plan? The intentional component is the action on the object, the succession plan, in this case, the will. Whether you thought you were screwing your son Alex or your son Tad out of it should be totally immaterial. It's
All right,
not-
so your position, if in intestacy, is that there's still interference, I take it?
Absolutely. The standing component for intentional interference with inheritance is you have to show the expectancy. In interference with a contract, the analogy or the parallel is you have to show a contract, not the specifics, not the terms, just that one existed. Well, a succession.
Well, I'm sorry. So what is the intent exactly? Is it the intent to commit a tort or the intent to interfere with the expectancy?
It's an intent to interfere with the object, the succession plan. And that can take a whole variety of different forms, very difficult to define. It's not the subject, Your Honor, Justice McDonald, it's the object. Your intent is to interfere with the object, not, I hate David so much, I'm gonna go interfere with Cletus Ireland's succession plan. So I think that's where I think the focus gets lost, and that's true for all our intentional torts.
So let's say a newspaper defames somebody and the defamation causes the testator to change the succession plan. And because I didn't know this, now I don't like this person I was going to give money to. Is that, in your view, an intentional interference with expectancy?
Potentially. I would not close that off out of hand, no, for all the reasons that I've talked about. But I'm not a First Amendment newspaper wizard on that. So putting those things aside, no, I think you would have a tort, the defamation, the proof, and where you lose where I think the intent's important is the defamation, you had to intend to interfere with the succession plan or the estate planning. That's where intent.
But if you look at the,
If party A defames party B and that causes party C to change his or her will, I guess I don't understand how that translates into your explanation of the tort, I guess.
Okay, so let me get this straight. If they don't know the expected beneficiary, you're saying, if the newspaper doesn't know?
They don't even know the person they're defaming is a potential beneficiary under a will. They're just defaming somebody. And
Okay.
that causes somebody to change their secession plan.
Sure, then I think you've got a fantastic defense that my comments never intended to attack the object. There was no intent, no intentional tort there. I think that's a terrific defense. But from a standing standpoint, that's meaningless.
well, let's work with the language of the third restatement, which we talked about in Youngblood.
Sure.
As you know. According to the third restatement, one of the elements you would have to prove, and I'm not saying the case was tried under the third restatement, but that's sort of the current version of kind of where the law is around the country. The defendant's purpose was to interfere with the plaintiff's expectancy. So, kind of following up on Justice McDonald's point, how do you show that the defendant's purpose was to interfere with the plaintiff's expectancy if they don't even know about the plaintiff's expectancy?
Simple. There's always a succession plan. So if your intent is to attack the succession plan,
That's not what the restatement says. It doesn't say the defendant's purpose was to interfere with a succession plan. It says to interfere with the plaintiff's expectancy.
absolutely, that's the standing component. How else would you interfere with plaintiff's expectancy? You interfere with the succession plan. Why would we have that element of required, again, going back to the extreme and absurd example?
But then,
well,
counsel, doesn't it require you to know that the plaintiff was expecting something? I mean, if you don't know that the plaintiff had something in mind, that the plaintiff had some expectancy, how's there a tort?
The tort is the action, the conduct taken on the testator and the succession plan. That's where the tort is. The tort is never the third party. We talk about it as a triangle. That's the conduit. You need, like a theft, you don't get to just say, well, I didn't know whose money it was, so I'm free and clear. No, the standing component is, it was my money, I'm entitled to a remedy, and that's the same works for intentional interference with the business, the contract. You don't have to know who they held a contract with. You don't have to know the specific terms. You just have to know that a prospective contract exists, or facts that would lead you to know that a contract existed. If we're going to get super technical, everyone has a succession plan. I know every single person walking around. If I go and
Counsel, if we assume, if hypothetically, I know you vehemently disagree, but if we impose a knowledge requirement, was there a fact question on this record that would preclude summary judgment? Should you get to the jury even with the knowledge element required?
Absolutely, and I think that's basically indisputable. I don't know how we got there under this record. These defendants had every circumstantial piece of evidence against them. They went to the lawyer's office with Miss Ireland. They spoke with her specifically about her succession planning. They talked specifically about and told her some ideas, at least that they admitted. They barged into the lawyer's office when he told them no for an estate planning meeting. There's handwriting that is not the lawyer's, as he admitted, all over these wills.
Isn't that her handwriting? Cletus's handwriting?
There's multiple different handwritings. One of them has sketchy, which appears to be Cletus's, but some is very fluid and good. And the lawyer admitted none of it was his. They had a key and unfettered access. They said they were the only ones around her in that entire time period, that they took care of her. They got her mail. The lawyer mailed the will to her address. The list really goes on and on. I know we listed 35 or 36 of them, but short of admitting, we had everything else. And without the other key piece, Justice Waterman, and that is a jury's entitled to believe their testimony or not. I think the jury should be given the opportunity, especially with all that additional circumstantial evidence. This isn't a case where they lived in the North Pole and had no access to anything and there couldn't have been any chance for it. There's quite the opposite. Like I say, you barge into somebody's estate planning meeting with their lawyer and the lawyer says no and you insist on going in, I think you're putting yourself in the henhouse.
Mr. Wonio, correct me if I'm wrong or misstating the record. Your clients prevailed on the will contest.
Correct.
So if we were to remand this and it were to go to a jury, what additional relief would be available to them?
Anything and everything under a tortious interference claim, I would think that would include, we've later discovered some damage to property, attorney's fees. We believe the case would warrant punitive damages, but again, that would be for the court threshold determination, and we do believe the case would present one for emotional distress.
Did your opposing counsel preserve error on the issues in the cross appeal, the closing argument and the hearsay?
No, and I'm very strong on that. The closing argument component, as the court will see, there was one objection and then a discussion off the record where we went up to the rail and defense counsel suggested that I was getting close to the line. We had abbreviated discussion with the judge, and I said I wasn't going where he said I was going, and that was that. There was no ruling on the objection. And certainly, as we've seen in additional cases, the trial court's the gatekeeper and the determination, or the sole has a sole discretion to decide if argument has somehow impacted the case to the point of no return. None of that was part of our record, and we certainly don't believe that the comments alluded to, and not just that, but I think we did chronologically point out some of the argument didn't make sense because certain statements were made earlier, and then they said later it was piled on. Long answer for no, I don't believe error was preserved and not even close.
I want to bring you back to the main issue. I've been cogitating on this kind of slowly maybe, but your position, I think, is that whenever a third party decides to befriend and influence a potential decedent with a view to, kind of getting an inheritance. Whenever that happens, regardless of their state of knowledge of whether there's a will, whether there's not a will, there's exposure for intentional interference if the elements of the tort are met. I mean, I assume that's your position, right?
Agreed with, I think, that major caveat you mentioned at the end, and that would be that the elements of the claim are met. Just
Yeah, sure.
because somebody's nice and befriending someone.
Yeah.
Okay.
Right. It's got to be improper, conduct and so forth. But isn't that kind of a sweeping proposition? I'll leave it at that.
Sure. I don't take it that way in the least. How could that be a sweeping proposition? If we meet the elements, that means that you committed a tort, whether it's fraud, duress, undue influence, or the like, with the intent of negatively impacting, changing someone's succession plan. How should that be in any way a surprise to the tortfeasor that they may be held accountable for that? That shouldn't be. And to suggest, well, just because I'm not going to expressly admit knowing who the specific beneficiaries there are, doesn't make that conduct any less culpable. I think it's a question of standing, and those are the people that get to bring the claim. It's an expectancy. There doesn't even have to be a will. There doesn't have to be an express beneficiary.
So your red light's on.
Thank you, Your Honor. Your Honors.
Mr. Wittmack?
Thank you. May it please the court, counsel. My name is Charlie Wittmack, and I represent the defendants, Appellees, and cross appellants, Patricia Birusingh and Kumari Durik, her daughter. To the justices, I think you've been asking all the right questions. How can you commit a tort without knowledge of the plaintiff? The other two related questions are how can you commit an intentional tort without intent? And the third related question is how can you commit a tort without having performed a tortious act? So this appeal raises three really fascinating issues. Obviously, the main event is what we've been talking about, the interference with inheritance tort. The second hearsay question is one that will be taught on bar exams, and the third issue with the violation of the rules of professional conduct, I think, are significant. So let's start with the tort, and we are talking about interference. We've talked about interference with business advantage, with contract. It's all really the same type of interference, and the three moving pieces are intent, knowledge, and underlying tortious conduct. The tortious conduct is, I think, an area where we have some work to do. And I think this is an area that jurisdictions all across America are struggling with, and I think the confusion comes from the concept of whether or not undue influence is sufficient to support this intentional tort.
Counsel, let me,
In Youngblood?
You did, Your Honor. Thank you. And I think that this case is a really natural progression of Youngblood. And the reason for that is...
Counsel, let me ask, was this issue preserved below?
Was this issue preserved below? Yes, it was, Your Honor. I didn't represent these parties at the trial court level. The issue came up at the trial court, and the question there was, what are the elements and were the elements proper? That's the issue on appeal now, and in preparing the arguments for you there, we're providing you with all the authorities that are relevant to that issue.
But was this issue on undue influence part of the discussion in the district court?
The issue was what supporting tortious conduct is required to be found, Your Honor, which I believe was preserved for this appeal. And it's a very...
Why can't undue influence be enough? I mean, it just says in the restatement, for example, it says independent legal wrong. It doesn't say tortious conduct. It says independent legal wrong, and undue influence is a legal wrong, isn't it?
Well, Your Honor, it's a very interesting point. So the third restatement differs from the second restatement. And with all the case law you see, including the Iowa cases that include, well, all 6 or 8 of them, every time they talk about undue influence, they're also talking about fraudulent conduct. So in most of the cases in Iowa, in the cases in other jurisdictions, whenever there's a discussion of influence, it's paired with those words fraud or other tortious conduct. The problem you've got with the third restatement is the third restatement limits the tort to say if a remedy isn't available in probate. So undue influence is best dealt with in probate. It's focused primarily on the impact on the decedent. When we start talking about intentional torts, and we start considering awarding all these remedies that Mr. Wonio is requesting, really I think judicial fairness requires some actual intentional act, something more than that, a showing of malice, defamation, some other fraudulent conduct, something greater that would warrant the award of punitive damages, emotional distress, and all the rest of these things that he's asking for. So you find in the case history that those two issues are linked. With respect to the tort claim, if you don't have knowledge and you don't have intent and you don't have underlying tortious conduct, that really is a probate claim, right? That really is a claim to set aside a will based on undue influence, and that exists in probate.
If we affirm the district court on its summary judgment ruling and its ruling that you had to have knowledge, we don't need to reach this independent tortious conduct issue, correct?
That would be true, Your Honor. Yeah, but for the issue of the fact that there was circumstantial evidence at the trial court level that could have created a material factual question on the knowledge element. I think here the more important issue is that undue influence is insufficient to support an intentional tort. Now, with respect to the knowledge issue, I know you're focused on that as well, Justice Manfield, and I'd like to say this. One of the very interesting things about this record is the plaintiff, Donna, has not been mentioned in any of the wills. She is the first cousin once removed. She's one of several siblings who are the daughter of an individual who was named in one of Cletus's prior written instruments. So that's the individual. This is not somebody that they should have known would take under this will. And in fact, the reason they shouldn't have known that she would take was because she's not actually explicitly named anywhere. So the knowledge element is a very interesting one.
Conceding that the district court erred in granting summary judgment on knowledge? I noticed you didn't brief that issue.
Not at all, Your Honor. I just think the issue is, the more significant issue is related to the underlying tortious conduct. And I think related to the knowledge issue, it's a very important point that the plaintiff was not explicitly named in any of the written instruments.
Counsel, the plaintiff has set forth, I think, 36 different circumstantial facts that they would point to as to why the district court should have let this go to the jury. Was the district court wrong on that?
No, they weren't, Your Honor, and it's because as I stated a moment ago, there was no direct knowledge in the record. The parties were not parties that should have been contemplated. And again, Your Honor, I think the more important issue is related to the underlying tortious conduct. What you have here is a finding where there could be...
So, counsel, if we disagree with you on the underlying tortious conduct and knowledge is the only element that we think is needed in addition, then do you think that this needs to go back for a jury?
I don't, Your Honor, no. No, I believe that the decision of the trial court should be affirmed. And no, there's no question about that, Your Honor.
Other than based on your notion that Donna was not named in the will?
There was no direct evidence in the record, Your Honor, that the defendants had knowledge of this. And
Well, but do we require direct evidence? What's wrong with the circumstantial evidence? If they would have seen, I mean, it seems like that there's evidence that that they could have seen the prior will or knew that a prior will existed. If there's some circumstantial evidence from that perspective.
Yes, Your Honor. Related to that is the issue of intent. So knowledge and intent are intertwined in this issue, and Mr. Wonio spent a lot of time arguing about the fact that the knowledge element is not even proper here. So what the court is contemplating is awarding damages on an intentional tort where there is no intent to harm the defendants, there was no knowledge that the defendants existed, and there
Well,
was no...
but if we satisfy the knowledge, if there's circumstantial evidence that there was knowledge that there were other individuals who were entitled, who were named in the will, and your clients came in and unduly influenced Cletus to change that, how is that not at least some circumstantial evidence that they intended to harm the plaintiff by benefiting themselves?
Well,
Or the defendant?
Your Honor, I don't think there's support in the record that there was the intent to harm. I think you...
Well, I guess let's go back to this knowledge thing. I mean, was there enough to get to the jury on whether your clients had actually seen the prior will? That's kind of what it comes down to. I mean, they're suggesting they had so much access to Cletus's affairs, to her home, et cetera, et cetera. Cletus was marking up the prior version of the will. They must have seen it. Is there an issue of fact there?
I don't think there's a material factual issue there. No, I think the district court handled that correctly, Your Honor.
Let me ask
Mr.
a
Wittmack, can I-
series.
Go ahead, Justice Apple.
Well, I want to ask just a couple hypotheticals. I know that there's a will, but I don't know exactly who's in the will. I know there's a will document that has been executed. Is that sufficient knowledge in your view? I don't know exactly how things are distributed, but I know there's a will.
Justice Apple, I believe all three of the elements are significant to the analysis here. First, that there was an intent to harm, and there's been a lot of discussion about that. Mr. Wonio was saying...
Well,
that,
but intent to harm the beneficiaries of the will. I don't know whether it's Jane or Sue or Bill or John. I know there's a will. I know there's beneficiaries, and I want to harm them by fattening my own situation.
In that case, Your Honor, if there was, I think in the hypothetical you're presenting, there was knowledge of the expectant beneficiaries, there was an intent to harm the expectant beneficiaries, and there would be underlying tortious conduct, I think that would prevail, certainly. I think in this case, the problem is all three of those are lacking. There wasn't direct knowledge of the parties, there wasn't any intent to harm them, and there wasn't any actual intentional tortious conduct.
Well, did they know there was a will?
They knew there was a will, significant.
Okay, well, then they knew there was, I'm sorry to talk over you. Yeah, this technology doesn't work quite as well sometimes, but if they knew there was a will, they knew there were a class of beneficiaries, surely, correct?
I don't disagree with that, Your Honor.
They didn't know their names, maybe. I didn't know exactly how it was distributed. I mean, didn't know the details, but wouldn't that knowledge be sufficient to support the tort?
Your Honor, I don't think that's sufficient to give rise to a cause of action for an intentional tort and the awarding of punitive damages, consequential damages, damages for emotional distress, attorney's fees, and costs. Mr. Wonio argued a moment ago that everyone has a will. So having knowledge of the existence of a will, I don't think is sufficient to give rise to an intentional tort under these circumstances. The reason that the significance of the fact that we need to have an underlying tort here is so important because when we're being asked to set aside a will in a will contest based on undue influence, the factual record looks very similar if the parties were acting in good faith as they were if they were acting in bad faith. So the factual record here is very persuasive on that. The physician, Dr. Birusingh, went to treat Miss Ireland after she fell and wrapped her arm. He was accused of practicing medicine without a license. The children took her to her doctor's appointments. They threw her a birthday party. They gave her gifts. They helped her buy her groceries. This is the factual record of this, what was described by Mr. Wonio as a Machiavellian plot, that they had marked her as a target. All these devious thoughts that were projected onto this. Now, there was no intent. The record doesn't show that there was an intent to harm these parties. The record doesn't show that there was direct knowledge that they even were beneficiaries under the estate. What the record shows is there was a family that was doing everything they could to be good neighbors and to be generous and kind.
Counsel, I'd like to switch gears on you a bit. The hearsay issue, which is the claim that you're pushing, relates to the questioning of what was said to Mr. Solhoff And the plaintiffs here have said that Mr. Cox, in asking a question on day one of this trial, raised that issue, right? That this, I think he said it stinks or it's dirty. And so the plaintiffs have said that that door was opened. And I think 2 days later in that trial, they asked the very same question, or at least a very similar question about it. They asked the first part of that question, and there was no other objection made as the testimony was coming in. What's your response? Why are they wrong about that?
With respect to opening the door, that doctrine involves two twin ideas. The first is the doctrine of curative admissibility, which doesn't apply here, and the second, which is impeachment. The hearsay statement originally came up when Mr. Wonio's co-counsel was examining a witness. It then came up again, an objection was properly lodged, and it was overruled by the court at that point. The objection was made, it was soliciting an out-of-court statement, which was being used to prove the truth of the matter asserted. It was a hearsay statement, that's uncontroverted, and the two initial explanations that were offered by Mr. Wonio don't apply here. In his rebuttal argument, he came up with 5 or 6 other explanations for why that
let me probe on that a little bit too, a little bit more too. All right, so I know you didn't try the case, but your client's trial attorney asks Mr. Solhoff, do you ever recall telling anyone that Cletus's will was dirty or that it stunk? All right, so that's in the record. Then later on, Mr. Buboltz, I think that's how it's pronounced, takes the stand, and opposing counsel, Mr. Wonio, asks him, what did Mr. Solhoff tell you? I mean, and in effect to impeach the prior statement that had already been, the testimony that had already been elicited and that was in the record. What's wrong with that?
I agree with your characterization of it perfectly, Justice Manfield, and the important word there was used to impeach the witness. And the testimony that was solicited was not being used to impeach the witness. It wasn't being used to show that the witness had a character for truthfulness or that he was distrustful. It was being entered to prove the truth of the matter asserted, and that's why it was improper. And it was a very powerful statement that Mr. Wonio used to weave through the entire
Counsel,
litigation.
couldn't it have been hearsay of Mr. Solhoff? In other words, Mr. Solhoff said, I do not remember saying that. And then Mr. Buboltz was asked about it later. Wouldn't it be to impeach Mr. Solhoff?
Except it was not being used for that purpose, Your Honor. That's the point I'm trying to make, is that it was being made not to say that he had a tendency to not tell the truth. It was being entered to prove the truth that his opinion, his legal opinion, as Miss Ireland's attorney, was that the will was improper. And that became his theme for why the will should be set aside, was that the decedent's own attorney said that it's dirty and it stinks. It's very damaging testimony. It is a hearsay statement, and the admission into the record was, it doesn't fit any of the exceptions, and it's not proper impeachment. If it was impeachment, it would have solely been used to show that his testimony was improper.
How did trial counsel preserve error on the closing, any challenge to the closing argument when there is no motion for a mistrial?
Yes, Your Honor, very briefly, since I know I'm out of time, we've included some citations there. There are certain circumstances where that's not required, and the legal standard on that is that conduct that's flagrantly improper or evidentially prejudicial, the case there is State v. Phillips, allows for an appeal on that and says that error was preserved. I think there could be no greater issue that would be flagrantly improper than a violation of the rules of professional conduct. And Mr. Wonio's defense to that seems to be that he does it all the time. I think under those circumstances, it does warrant a remand and a retrial. So in conclusion, Your Honor, we would ask that the district court's motion for summary judgment be affirmed and that the case be remanded for a new trial based on the hearsay issue and the violation of the rules of professional conduct. Thank you.
Mr. Wonio, a rebuttal.
Thank you, Your Honors. I'll jump around a little bit, but I do want to start with a concern I'm having. I feel like I'm in a legal laboratory. Mr. Smith and I try these will contest cases all the time. How this is being presented and kind of stacked on top of itself is not how these things play out, and they wouldn't. For most people, a will or a succession plan is a personal, intimate, secret type of a deal. This court, as I started out with, has been so great because it's preserved these avenues for recovery, for remedy to injured Iowans. What logic does it make to say you can have the exact same abhorrent conduct in stealing somebody's inheritance, but you're off the hook if you don't know who the specific expected beneficiary is? It makes no sense. It's like demanding in the interference with contract to know who the contract's with. The focus isn't on the subject, it's the object. I want to go get all your farmland, Justice McDonald. I'm going to come in and I'm going to defraud you. I'm going to lie to you. I'm going to unduly influence you. My goal is to get that. I don't care who the beneficiaries are. I know there's somebody by product of succession planning or state laws we talked about. I know there's somebody. The standing piece is that somebody, not my conduct needs to be geared towards that person. That's not this tort. And I
But
feel
I mean, we have different kinds of torts. We have things like product liability and negligence. And the reason why our court opens the door to those torts is partly it's an important social policy. We want to encourage manufacturers and landowners and drivers to be more careful. This is different. This is meant to be an intentional tort, which is a higher burden. And the reason it's a higher burden is because we don't want false positives. We don't want people who just happen to treat somebody in their last years nicely to end up having to, not only to lose whatever they were going to get under the new will, but also to have to pay damages unless it's really warranted, unless it was really intentional wrongdoing. So there's a reason for a higher threshold here, isn't there?
Absolutely, and you're hitting the nail on the absolute head. You're contemplating a scenario on the front end, the vanilla one, where somebody's just being nice. Well, there's no tort. There's no intent to do anything wrong. But if you're going to commit a tort, which someone would have to prove under a tortious interference, if you're going to commit a tort with the intent of stealing something, stealing the inheritance, it shouldn't matter if you know who it's specifically going to or not. What logic does
Counsel,
that?
can I, sorry
Sure.
to interrupt you. So under your view of the tort, is it any different than an undue influence claim?
Oh, absolutely. You've got to have the tort and you've got to have the intent.
Well, I thought you said undue influence is the tort. So in this situation, are you relying on additional elements beyond what you've already proven in your undue influence claim to prove an intentional tort claim?
Absolutely.
And what are those elements?
Several different things, and this does dovetail with something I heard from my learned counsel. We didn't get the opportunity to explore the supporting conduct, as he said, but we asserted fraud, duress, undue influence, and I think some others. But this was a fraud case. This wasn't an undue, from a tortious interference standpoint. This was a fraud case. And I'm confident. I heard about how bad our factual record was, but our jury was out about 30 minutes. And I disagree totally with this idea that these were folks trying to help out innocent old Cletus. And I think our record doesn't support that. But to get to your point, yeah, I think there's a lot more. That issue wasn't preserved and isn't preserved for this court because we never got to develop it. We got thrown out on a summary judgment, not because there wasn't evidence of fraud or duress or undue influence.
Okay, but you're
because
still
of-
not answering, if undue influence is your underlying tort, what additional would you need to prove to also prove an intentional, the intentional tort that's at issue?
Sure, your intent, you have the tort, let's just say you've got a case where a person committed this undue influence, that's your tort. The intent in committing this is to take the land for yourself or otherwise interrupt and break the succession plan
But
of.
how is that different than the undue influence claim?
The undue influence claim is focused on the testator in a probate proceeding. And that could be done without the intent. Maybe she took comments improperly or received them, and it was never, let's give you another example. I'm over trying to steal Justice Mansfield's farm again from his two boys. But I'm not over there for that purpose this time. I'm just over there bad-mouthing his kids, right? I never had the intent or bad-mouthing one of his kids. Let's say then, based on that, he switches his estate plan because he's infirm or susceptible to this influence. But it was never my intention to get the land for myself or to interrupt that estate planning. That's the distinction. That's the flip side. And yeah, to your point, Justice Mansfield, we've got a heightened burden there. But this concept of knowledge is not part of it. It doesn't make any sense. Thank you, Your Honors. Again, this court has preserved, to the benefit of all injured Iowans, these avenues to recovery. There are no cases where that preservation is more important than in the estate planning. We do ask that you remand this for proceedings consistent with what we've asked for in our brief, and that the issue of tortious interference be presented to a jury. Thank you. Appreciate your time.
Thank you, counsel. The case is now submitted along with the 2 cases scheduled for non-oral submission this afternoon. Bailiff, you may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.